Andrew Cuomo, the New York governor, has just recently resigned from his employment as the governor of the state of New York, given the fact that he's got about 11 charges of sexual harassment against him. His statement was that he wanted to make sure that the state can continue to govern, and the last thing that New York needs to focus on is a harassment scandal. From a legal perspective, resignation of an employee who has potentially committed harassment doesn't necessarily absolve the company or the individual from liability for sexual harassment. Under most laws, harassers are typically individually liable for sexual harassment or any other type of harassment. In addition, under typical sexual harassment law, if a coworker harasses another coworker, the company may not necessarily be liable if the company is not aware of it. On the other hand, with regards to supervisors, a company is typically automatically liable for the individual supervisor's sexual harassment, even if it doesn't know about it. What it can do, though, is try to mitigate damages and argue that had they known about it, that they would have been able to try to reduce those damages and potentially try to minimize the harm to the individual. So here, because Andrew Cuomo is the governor and the highest person of the state, or the highest employee in the state, that's probably going to be considered a strict liability claim for sexual harassment, period.